a vitally important issue to the future of our state. We're going to discuss the use of civil non-disclosure agreements and settlements involving the sexual abuse of a child. Our first panel, we've got two panels. Our first panel, let me call you up here to come join us. Cindy Clemishire, Kathryn Robb, and Elizabeth Phillips. Give me just a second. Okay, thanks to each of you for joining us today. I mentioned earlier before the three of you got here, but I want to make sure that you got word of it. The committee members, even though they may not be here on the dais, they're coming and going. They can hear you. They're listening to you. Their staffs are listening to you as well. And it's that time of day. We've been sitting here for 3 hours. A couple of them may need to grab a bite to eat or coffee or go to the restroom or whatnot. So we're very glad that you're here. This is an important issue to this committee, and your testimony is vital to us today. And so thank you for being here. Elizabeth, I'm going to ask you to go first. We're going to go Elizabeth, Cindy, and then Kathryn. And so thanks for being here. If you'll identify yourself, and the committee's glad you're here today.
Thank you, Chair Leach. I'm Elizabeth Phillips from Dallas District 108. Thank you. I know we're between you and lunch, so appreciate your attention. I'm here to speak today on behalf of my late brother, Trey Carlock. He would have been 34 this Monday. I'm also certified in crime victim advocacy and serve as the executive director of the Phillips Foundation, which privately funds the issue we're briefing you on today. I said my brother would have been 34 on Monday, but because he was silenced to his grave by Kanakuk Ministries, a summer camp based in Southwest Missouri. Texas is their largest market, though. He is no longer with us. First, he was groomed and abused from the age of 7 to 17 by a serial sex offender named Pete Newman. Then he was forced by the Texas Civil Statute of Limitations to file his civil case against Kanakuk before the ripe age of 23. That stressful and re-traumatizing civil litigation process ended with a settlement involving a restrictive NDA. I have actually learned more about the extent of my brother's abuse and his death than I knew in his life. He died by suicide in 2019, and now that I've caught my breath, I'm trying to be his voice. And not just his. Since my family was public about Trey's abuse in the Dallas Morning News obituary, we've heard from countless victims who have similar stories to Trey's. These boys, now men, have been suffering in silence from the NDAs Kanakuk and its agents demanded behind closed doors, with attorneys who would gaslight and intimidate victims in depositions that led to my brother's first psychotic break. Separately from Trey, Kanakuk sanctioned a Texas John Doe whose parents refused to sign the NDA clause on behalf of their minor son, costing them an additional $40,000 in legal fees. It's so hard to fight wealthy institutions while you're also fighting for your kid's life. Many other parents did silence their children inadvertently when they signed settlement agreements with Kanakuk on behalf of their minor child, not realizing they had signed away their son's voice. Not only was his innocence taken, but then his voice too. When survivors coalesced and called Kanakuk out, we posted a petition and got 30,000 signatures for the release of NDAs by Kanakuk. And when I say my brother was silenced to his grave, I mean he was literally scared to death. He hesitated even to tell his story in confidential therapeutic settings for fear that Kanakuk would come after him again, like they did an earlier John Doe. He said to someone a few days before he died that they'll always control me and I'll never be free. And that's what it feels like to be put under NDA when you've survived a childhood crime. I believe when he said that, he was talking about the NDA, and what's unfortunate is that NDA is still enforceable even in his death, according to the probate attorney of his estate. And sadly, a lot of truth dies with people because of NDAs. I've read some of the NDAs these victims are under, and they're atrociously detailed and have everything to do with protecting an organization's reputation over the interests of an abused child and his long-term healing. It's no exaggeration for me to claim this as a matter of life and death. Why is this life and death? I think we know what child sexual abuse does to a person's life, does to a kid. And I think we also know how healing happens. It's by sharing your story in safe places, finding support and solidarity in the midst of navigating unfathomable pain. That's the whole basis of cognitive behavioral therapy, the Alcoholics Anonymous model. When you take someone's voice away, especially a child's, you take away their most linear path to healing. Sexual abuse happens in secrecy and shame, and we need to take the furtherance of those shadows off the table in the civil courts of Texas. This should be a welcomed measure of justice so that future child crime victims do not have my brother's outcome. I get asked a lot since becoming more public about this issue on a national level. Why would your brother sign an NDA? Was he physically forced? He had a choice. Well, actually, when you've been abused and gaslighted and re-traumatized in a civil litigation process, you're exhausted just trying to function, and an opposing counsel offers you 7 figures if you just sign on the dotted line saying this will end, just sign here. The system is abuse on top of abuse. So out of exhaustion, my brother and many other Kanakuk victims sign on the dotted line. They need money for a lifetime of care because crimes perpetrated by a serial sex offender and institutional leadership that enabled the predation have changed their lives for the worse. And it's a lifelong healing journey. But for them, it's not about the money. My brother referred to his settlement as blood money, as if he had betrayed his own soul to keep Kanakuk secrets. And it killed him. So institutions that have something to hide want full secrecy and confidentiality clauses. In civil litigation, they nearly always start with an extensive and comprehensive NDA and a settlement agreement. They go by many names: non-disclosure, non-disparagement, confidentiality clause. But what we're talking about, I'm using the term broadly, NDA. It's actually become quite widely accepted as best practice. Money for your silence. It sounds like a bribe to me. And unless you have a trauma-informed advocate, you may not read the fine print or realize you're signing away your voice in that moment. You just want the re-traumatization to end. This practice is nothing short of evil, as it protects darkness, and bad actors only win. We need to change this widespread abuse and misuse of NDAs in Texas. NDAs are for trade secrets, not trauma secrets. There's another quote that says, "Shame dies when stories are told in safe spaces." Tennessee made itself safer in 2018 when they passed a bill eradicating the misuse of NDAs in civil child sexual abuse cases. 17 other states have clarified the NDA issue for their courts too. A movement has been building with organizations like Lift Our Voices and NDA Free, leading a global conversation on this topic. The federal passage of the Speak Out Act in 2022, which Phillips Foundation supported, had overwhelming bipartisan support. And that tells me that as Americans, if we were ready to eradicate the weaponization of NDAs against survivors of sexual harassment in the workplace, surely this state, my state, is ready to assure and extend the same protection to children and child trafficking and child sex abuse victims particularly. It's the least we can do if we're to be the responsible adults in the room. Should this be granted a hearing during session, survivors stand by to testify on the harm of NDAs, the silent killer. Yes, silence actually kills, as my family knows. We hope that Texas chooses to join this movement and that it's an easy decision, a moral one, and deemed an urgent matter of public safety and concern. Thank you for your attention to this critical issue and for welcoming survivors' perspectives. Our panel will continue to provide testimony, and we're happy to answer questions.
Thank you, Elizabeth. Thank you for sharing your story with us. And yeah, let me go to Cindy and then Kathryn, and then we'll have some questions for you. Cindy, thanks for being here.
Well, thank you. don't feel so bad about the notes that I have after listening to all the things we've listened to.
Yeah.
So I just want to start out by also saying thank you for having me here. I actually am a resident of Oklahoma. I'm not sure how many of you are aware of my story, but my story went public on June 14th with about Gateway and Robert Morris. And I am the 12-year-old that he sexually abused for over 4 years. It started on Christmas night, December 25th of 1982, and I'm just going to give you a few highlights of some things about the abuse, but even more so about my adult life. Like I said, I was 12 years old, and I was wearing pink pajamas, and what he told me after he abused me the first time was, "No, you can never tell anyone because it will ruin everything." As a 12-year-old little girl, I didn't understand what that meant.
How old was he at the time?
He was, I believe, 21 or 22. Well, I think he might have been 22, maybe 23. There's about a 10 to 10 and a half year gap, I believe. So I didn't want to ruin anything. And this was a close family friend as well as what was considered a spiritual leader as a traveling evangelist. This did go on for over 4 years until I finally told when I was 17. I shared with a mutual family friend who was also a friend of the Morrises, and she, in turn, had me tell my parents. Back in the 80s, this is not something that was discussed. So to think of going to share with any legal services, that just wasn't discussed. So Robert went on to live his life supposedly with a small step down from ministry to receive what they called restoration. It took me about 20 more years until I fully understood the term abuse because it was not aggressive, what I experienced, and it was a family friend. I was 37 years old when my attorney actually reached out, even though the statute of limitations had expired, to try and receive about $50,000 is what he asked for my counseling. At that time, I was re-victimized by being told I was the one to blame, that I was the one at 12 years old that pursued a married man with children. In turn, they offered me $25,000 as long as I signed an NDA. I'm sitting here today because I did not accept that offer and refused to sign an NDA saying I couldn't speak about my life. When you compare his life to my life, if you know who he is, and I think that this happens a lot in child sexual abuse victims' lives, people think that it's about what happened physically to us, but what actually carries on throughout our life is the disconnect that was made and the development that we missed out on, both physically, mentally, spiritually, emotionally, and the compartmentalizing that starts taking place. And there is scientific evidence of the trauma in our brains that they have been able to prove. You know, Robert continued to build a ministry and a life, writing books and growing his wealth and his platform, while I do have some wonderful things that I've experienced in my adult life, I also have had multiple marriages and incurred tens of thousands of dollars in counseling. You know, while I was trying to make sense of my brokenness in my life and rebuild and protect my own children from child sexual abuse, you know, he was building that platform that today I'm thankful we are able to use to talk about this subject. I'm 54 years old. I'm a mother of 3 and a grandmother of 3. And the average age of someone to speak is 52. I believe that I'm here for a few important reasons. One, I have an amazing family and friends that have supported me all the way through to this day. I did spend countless hours and dollars in counseling to be able to be here today, not knowing that this day would ever come. I did finally share my story privately, as I have for 4 decades, to the right person, a retired pastor, Wade Burleson, who encouraged me to go public with my story in order to help end child sexual abuse. But I think the biggest reason that I am able to be here today is because I refused to sign the NDA. I'm not here just for myself. I'm here for what I believe in 2021 they assume are over 42 million adult victims of child sexual abuse living in the United States. That's living. And I just hope to see the future change so that it's normalized to talk about it, to expose it, and to prevent it. And allowing people to speak freely of their experiences is the only way that that will ever happen. Thank you.
Thank you, Cindy. Thank you for sharing your story. We'll have some questions here in just a sec. Chair calls Kathryn Robb, National Director of the Children's Justice Campaign at Enough Abuse. Is that correct?
That is correct.
Okay, thanks for being here.
Thank you, Chairman. And thank you, members, as well. And again, my name is Kathryn Robb, and I am the National Director of the Children's Justice Campaign at Enough Abuse. I'm also a survivor of child sexual abuse by a family member, but my role here today is primarily as a national expert on child protection legislation. I've been doing this for 22 plus years. I testify all over the country for any sort of child protection legislation. So you have to be kind of living under a rock to not know that we are living in an epidemic of child sexual abuse. The research says somewhere between 1 in 9 or 1 in 11 children will be sexually assaulted before their 18th birthday. If that's not an epidemic, I don't know what is. All children are affected, regardless of their race, culture, religion, parents, political backgrounds, right? It affects all of our children, and all children are in danger. And the burden really sits on the state. The burden is on the backs of taxpayers because this epidemic just destroys lives. It affects our educational system. It affects our social service systems. It affects our medical systems, our mental health systems, our penal systems, law enforcement. I mean, you name it. It just has a financial burden on taxpayers and certainly the state of Texas. But in addition to that burden, and it's monumental, is the problem that we see with NDAs and what you've heard here already today. Historically, NDAs have been used to protect in business and employment trade secrets, confidential list, that sort of thing. And that makes sense. That's sound public policy to me. Not to cover up wrongs and crimes, especially against children, right? That wasn't the intent ever for NDAs. It was to protect businesses, employers, and their confidential trade secrets, confidential information, that sort of thing. Presently, we have 17 states and Congress that have passed laws that prohibit the use of NDAs overall for sexual abuse cases, but primarily for sexual harassment. We are seeing more states entertain specifically a narrowly drawn bill to address ending NDAs for child sexual abuse, because it's really such a horrendous wrong and crime. They're simply just contrary to public policy. It doesn't make sense to silence victims, and they do. They silence victims, but they also endanger children, and this would be the piece that I'd really like to emphasize here today. They endanger children because they shield sexual predators, right? They cover up prosecutable crimes against children, mostly felonies against children. They conceal negligent acts and practices by institutions and organizations. And as we've already heard, they re-traumatize victims. And overall, when that happens, it prevents victims from fully healing, right? From fully moving forward and having a healthy life. Although this is something that survivors live with, for decades and decades. We know that it takes years and years for decades for survivors to come forward. Many take this ugly secret to their grave. I would like to share just a personal story. This is my son, my oldest son. I'm a mother of 5. This is my oldest son, Jesse, and he's 9 years old in this picture, playing Little League, right? And a year and a half ago, my son, who is now 30, came into my office, and he sat down. He closed the door, and he sat down.
This is your son?
That's my son,
He's
but
30
he's
now?
now 30,
Okay.
yes. And he came into my office, and he sat down, and he said to me, "Mom, I really need to talk to you." And I said, "Okay." And he broke into tears, and he said, "Mom, when I was 9 years old, remember you took me to the ER for this illness he had. He had a high fever." And I said, "Yeah, I remember." And he said, "Well, the doctor took me to the basement of the hospital, and he raped me." And my son held that secret for, 22 years or so, right? And I'm in this business. I've been doing this for 22 years, and I thought as a parent I'd be able to see it. I always knew something was wrong with my son. Something wasn't quite right, right? He had an issue with alcohol. He had an issue with drugs. And I knew that something wasn't right, and this was what made sense to me. Of course, it blew me away. As a mother, I still carry a lot of guilt and shame of not going when the doctor said, "We're taking your son for a test." How would I ever know that I would not be able to trust a doctor at an ER and that he would take my sick son with a very high fever to the basement and rape him? There's no way I would know that. But the reason I'm sharing this story is because my son said to me at the end of that, in a bucket of tears, "Mom, I have felt like I have been held under an ocean of water, and today I came up to breathe." But if he has to sign an NDA, he will be pushed under that ocean of water again. And that's just to illustrate how inappropriate NDAs are for child sexual abuse claims. Now, I know, and I'll just end with this, I know, just because I testify all over the country, I know that a lot of organizations and institutions will say, "Well, you know what, we're not going to do that anymore. Just this is going to be our policy, this is going to be our procedure, this is going to be our new day forward." But it can't be up to them. It cannot be up to an institution. You have the power, you have the authority to not silence children and victims again, right? We can't have it be up to them. It has to be law that NDAs do not make sense in child sexual abuse cases. Now, I would say they don't make sense in most cases, sexual abuse cases or harassment cases. We certainly saw this with the Speak Out Act at the federal level, but it's just bad policy. And it is the legislative body that has the power, the authority, and I would say the wisdom to change this law so we can protect our children. Thank you.
Thank you for your testimony, Kathryn. So I imagine you have copies of some non-disclosure agreements that you've seen.
Yes.
And then if you could provide some of those to the committee. I'm not sure we have them provided yet, but I think it'd be helpful for the committee members to put our eyes on exactly what's being what the language is in these non-disclosure agreements. Can you describe to us essentially we all know what NDAs are generally, but if in these situations you have, well, let me just ask you, and then you can describe what they say. Are these situations where where someone like in your son's situation is now at the age of majority, so he's 30 years old and he's reporting a crime. He's communicating a crime that took place, in this case, 21 years before. Are we talking, when we're talking about NDAs, are we talking about those situations where someone who can consent to such an agreement, a 30-year-old, in exchange for a settlement from the hospital, is agreeing to sign one of these NDAs?
So we are, first of all, we're not talking about the criminal sector at all, right? So we have the criminal laws and the civil laws. We're only talking about civil laws. We see these.
Sure.
So, and they're a clause. They're actually not an agreement. They're a clause within a settlement agreement that prohibits both parties from speaking. Now,
For prosecutable crimes is what you said, though, correct?
Well,
and I'm just trying to understand specifically what the language in the agreements is referring to.
Well, lots of jurisdictions say unenforceable, void, contrary to public policy, right? We can't have them for covering up crimes. But here's my point. Survivors don't know that.
Right.
Right? So, yeah, they're contrary to public policy. I believe any judge would throw that out immediately. But I'm just saying overall, victims don't know that. Survivors don't know that. I mean, they're already struggling, right? And it's very hard for them, to wrap their minds around that. And there's also a piece, with victims of child sexual abuse, they're desperate to get this behind them. They're desperate to find a new day, right? And so they feel there's a loss of power, and that's the other piece to this. There is this imbalance of power when we're negotiating these sort of agreements, right? So, to answer your question, generally it's a clause within the settlement agreement, and some of them will have, you can speak to your spouse. They'll limit the amount, the prohibition on disclosing any material terms. Some of them also say you can't, speak about the amount of the settlement, so they vary per NDA. But essentially, they tell the survivor, they tell the plaintiff, they cannot talk about this. And this is really dangerous because if they're silenced, like I said earlier in my testimony, then that means we don't know that an institution has failed, right, and continues to have really crappy practices, procedures, standards, training, all of that. So therefore, our children in the future are in danger, right? But they also can't speak to protect children, to say, I think it happened to this one, I think it happened to another person. And then they have that guilt of not coming forward and sharing that information. So it's a real danger to children prospectively, right? It just puts children in danger.
Sure. Elizabeth.
I can speak to some of the specifics of the language in Kanakuk NDAs that I've seen. So, a lot of times people will say, well, actually even Kanakuk said the plaintiffs requested the NDA. And if you ask the plaintiffs, they will firmly deny that. And when you read what's in these NDAs, it's unilaterally silencing the victim. And these are 3/4 of a page long, not your simple confidentiality clause that protects the name of the minor plaintiff or the child sexual abuse victim. Language including, you will not disparage Kanakuk, its officers, its agents, its counselors, its staff, blah, 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 long list, either in media, on social media, to the public in a hearing like this. I'm here to represent the voices of so many victims of Kanakuk abuse who feel unsafe to speak out. And whether or not the exact language in their clause prohibits them from being in this room today, they sure feel intimidated into remaining silent on what happened to them, with fear that Kanakuk will come after them because they've done that. So when I said earlier, we're using the term NDA broadly, but these show up in settlement agreements as a confidentiality clause, a non-disparagement agreement. They go by different names. But the moral of the story is we're silencing child crime victims, and they don't know their rights necessarily, as Kathryn mentioned. And so they just take it as, okay, I've got to take my money and shut up and not speak of this again. And it protects the institution, right? And it doesn't, if they can't come forward, publicly like Cindy was able to, then other victims are also still in the shadows. And that doesn't serve the public good.
Cindy?
I just wanted to add to, I did not, I said, I did not sign an NDA regarding silencing a victim at age 30 or in the 20s and them hoping that it puts something behind them. I mean, I understand that feeling, constantly wanting to put it behind me. I'm 54 and I've been dealing with it since I was 12. It's a lifelong journey. It doesn't matter how much money anyone receives in a settlement, they will continue the journey
Sure.
of healing and living outside of shame. When my story broke, I received countless messages privately on Facebook and Instagram, and one of them was from a 90-year-old woman who told me she was abused, sexually abused at 14, had gone to at least 20 different counselors in her lifetime, and finally felt different when she heard my story and when I spoke out. It was like I was her voice. So if a 90-year-old lady is still living in shame and trying to sort through the brokenness of her life, I mean, it's not going to end with a settlement. It's a lifelong journey. And to tell someone they can't speak of that ever again, I don't know how that could ever be in the best interest of a victim.
So just so I understand, I agree 100%. Just so I understand the timeline. So you were 12 years old in 1982 when the
Correct.
abuse started, correct?
Correct.
And it continued on for how long?
A little over 4 years. It
Okay.
was 1987 when I told.
And then when you told, and he was so in your instance, he was at a different church at the time. They suspended him, I guess, for 2 years while he underwent.
That's what they said, but
That's what they said,
there's
right,
evidence.
Right.
that
So,
different.
and then he became at some point or started Gateway and became the senior pastor at Gateway, was there for a long time.
24 years.
There are reports that he was, had an estimated net worth of over $100 million.
Correct.
Certainly one of the biggest churches anywhere in the world, was one of the leaders, and at that time, the president's faith advisory board. It's crazy because, I myself listened to his sermons on numerous occasions. I have one of his books at home.
Right.
Don't have it anymore. But during that time, so in 2000, when did you approach through your attorney when did you initially or report it through your attorney to the Gateway Board of Elders or to the church?
There was an email sent from me personally to Gateway in 2005, and there was some dialogue that went back and forth for approximately 6 months with Gateway and Robert and Debbie that ended with a phone call, and he was pushing me to tell him a figure that would keep me quiet. That this is out there, I believe, pretty public information at this point, and I responded with, there's no amount of money that could ever correct this, and I did throw out a figure, I think at the very end, because he just kept pushing, for $2 million. He immediately said okay and ended the phone call. It was about a year and a half later in 2007 when my attorney, Gittner Drummond, who is now the Attorney General for Oklahoma, sent a letter to his attorney asking for $50,000, and that was in 2007. And he laid out the dates and my age in that request for $50,000. I had accumulated up to around $25,000 to $30,000 of expenses that I had spent in counseling up to that point. And we just thought it would be reasonable to request for an additional $25,000 to continue to go to counseling. I was 37. I had 2 sons at that time and was pregnant with my third. So, when they responded with, it was my fault that I was the one that had pursued, and, he had basically been the victim, was how they responded, and then said they would like to know who I was going to for counseling. They would be willing to give me $25,000, and they wanted me to sign the NDA.
Did they send you an NDA to review?
I don't have it. If they did, I know that Gittner spoke to the attorney, and there may be some documents still in the file pertaining to that.
Yeah. How did that make you feel when they asked you to sign an NDA?
Well, I'll be honest, I had never been in any type of business or legal battles at all, so I didn't even know what it meant when he said NDA. I said, "What is that?" And he said, "Well, it basically means you won't be able to talk about this anymore." And I said, "Absolutely not." Like she said, they're controlling me still. You know, that's how it has felt. Like they still have control of my life if I did that. And like you said, you've listened, like hundreds of thousands, if not millions of people have listened to him preach for the last 25 years. And I was not one of those. But since my story came out, I have seen many of the short reels where he blatantly lies and shares my story and twist it to his benefit, still portraying it as an affair, calling me a Jezebel spirit, just building his wealth off of my story, but twisted in lies.
So it's just devastating, and you've been so brave, and we've all followed the story and read and watched all the documents, and you know, thank you. Recognizing, I think one of the sad parts among many for me is that there are millions of people, of victims, boys and girls who are in your position who aren't yet quite ready and may never be, and that's totally fine to speak publicly about it. They're in the shadows now. And the fact that many of them have signed NDAs simply because they may have needed the money to pay for counseling.
Right.
And Kathryn, are parents signing NDAs on behalf of their minor children?
They have the power to do so.
How do they have the power to?
Guardians can do this if they step in the.
But once the child becomes.
Yeah, I mean, you don't usually see that. You usually see it much older, primarily because it takes victims a very long time to come forward. But I just wanted to point out one other thing that makes this very applicable to child sexual abuse claims. Many, many survivors cannot emotionally withstand a trial. Mm-hmm. They just can't. They may not even be able to get through discovery and depositions and all of that. So that's why we see a lot of survivors saying, this might be the best route. And some really good attorneys will advise their client, this is going to be very, very hard for you. You're going to be re-traumatized. We've seen survivors end up having to be, put into a psychiatric ward in a hospital as they get closer to trial or right after a deposition. It's extremely traumatizing. So you just see more settlements in these types of cases.
Can you help me understand in the situation, like for instance in Cindy's situation, where clearly his attorney, probably his wife, and certainly some of the Board of Elders knew that this had happened. Are they not mandatory reporters? How are people requiring victims?
Were they then?
Were they then?
I don't know if they were then, because it's when the abuse occurred that they would be a mandatory reporter, unless I'm misreading the Texas law.
So I need to have a better understanding. One of the things we're also going to discuss, I believe strongly we need to discuss, is escalating the penalties for mandatory reporters.
Right.
But were they not
typically
then,
minimum.
Were they not then at the time, considering he was still the pastor, mandatory reporters?
I don't know the answer to that, but it would certainly.
Elizabeth, jump in.
The statute on that is very short. But I want to respond to your question about parents signing NDAs on behalf of their minor children. We've seen it a lot in the Kanakuk cases. Logan Yandel, who is a public plaintiff suing Kanakuk for fraud, civil conspiracy, and negligence right now, He was put under an NDA by his parents. They agreed to a quick settlement, trusting Joe White's narrative about the abuse by Pete Newman at Kanakuk. Evidence shows quite a different narrative right now. But when he initially reached out to an attorney as a grown person, not a minor, later on, wanting to talk about this, the attorney told him, well, you will have to sue your parents to get out of the NDA that they signed when you were a child. So that's the position child sex abuse survivors, child trafficking survivors, child crime victim survivors are put under when their guardians may not be educated about what the language of an NDA exactly means. What is the ramification on their child's life? And so that's why we're fighting, the Kanakuk survivor community is fighting this NDA issue, because a lot of these victims were silenced as children, and they're now adults ready to speak out and legally cannot.
Is it your position, either Elizabeth or Kathryn, any of you, that the state should just, as a matter of public policy, void all make it just prohibit anyone or any organization from being able to ask for an NDA for quote prosecutable offenses? How would you describe that, or how would you define it?
I think that they should be void and unenforceable for child sexual abuse claims, period.
Void and unenforceable, so what would the penalty be for someone even asking for one?
That could be another step,
Right.
right? Certainly that.
Mr. Chairman,
Yeah.
I want to jump in
Yeah.
to your
Chairman
question, and I'm directing it to you. I think that we're not explaining it well. You still want to make sure that if there's agreements in place, that they maintain confidentiality of the victim. So for the parties that are not the victims, the individuals or the company or institution, they would still be obligated, if that was the wish of the victim.
Correct.
They can't go disclose. This should be a right that only the victim and the victim's guardians or parents have the ability to do.
Agreed.
Okay.
Agreed. Well said.
I can read a sentence of specific language that Tennessee passed, if that would be helpful.
Yeah, it would be.
Okay, so notwithstanding any law to the contrary, any provision of a settlement agreement that has the purpose or effect of concealing the details relating to a claim of child sexual abuse is void and unenforceable as contrary to the public policy of this state, except that identifying information concerning a victim of child sexual abuse shall be deemed and maintained as confidential.
Was that in? You said that was Tennessee.
That was Tennessee under Governor
Was
Haslam
that
in 2018.
Was any part of that retroactive? Did it void existing?
It says void and unenforceable.
Do you, Kathryn? Kathryn, you're
Which
not
is
from Texas,
prospective.
right? Where are you from? Are you from
I'm from Connecticut.
Connecticut? Okay. So I don't know if you've been able to thoroughly research Texas law, but I would like an opinion as to whether the legislature can void existing NDAs.
I would say unlikely.
Unfortunately, I would agree
Yeah.
with you, but
I mean, you do
That
have
language that you
a
just read from
provision in your
Tennessee
Constitution
certainly-
as well on
say it again.
retroactivity, so.
May I, Chairman?
What, Representative Scove?
You're going to make me go back and look at our 200-page Constitution, but I think there's actually a provision of our Constitution that prevents the legislature from interfering with existing contracts.
Yeah,
That
the
is certainly
contract clause.
there, but
Yeah.
if a contract is already void and unenforceable as a matter of public policy,
Yeah, that's going to be,
I agree.
I think functionally, that's how it would play out. You can't go and undo what's in the agreement, but if that party then tries to enforce it, the party on the other side of it can say, no, this should be null and void. Look, even the legislature spoken and said these are against public policy, and the court at that point would probably say, you're correct, we're not going to enforce this provision. Then they are doing it, not us interfering. I think that's functionally how it would work.
That's how it is working. There's precedent on that in different Speak Out applications of the Speak Out Act, such as in South Carolina. That's what we're seeing on that issue.
I think the hope would be is if the legislature engaged in something similar to that, the message is very clear, and parties trying to assert that provision probably are not being well advised by their counsel. So I mean, my hope would be that when you make a public policy statement like that, because you're laying a marker down, right, as the policymakers in the state, you would hope that that is not something that would have to be further litigated because it's very clear in the law. But again, you never know. But those are some of the things that would.
Well,
I don't think it is retroactive in that sense.
It's
saying any going forward can't include it, but it's also saying, I think, if someone tries to assert enforceability of this one, there's going to be an opportunity for that victim to say, hey, I know I signed this, but this should not be enforceable, and the court could make that determination, and probably would.
well,
I mean, it could be like any other contract offense.
Yeah, that's what it
Mr. Chairman,
yes.
I
Representative Slauson.
recognize that the value for the perpetrator of these NDAs is in large part the chilling effect that it has on the speech, and it's not necessarily the recompense that they might want to receive for a violation of it. So to that end, my question is, how often do we see offenders trying to enforce the NDA provisions when someone finally works up the courage to speak out anyway?
Great question.
I can speak to what we've seen in the Kanakuk cases, and when a family got down to the wire, ready to sign on the dotted line, they saw this NDA. Their counsel was trauma-informed enough to say, this is the ramifications of signing that. They refused to sign that NDA. Then Kanakuk sanctioned them. And a judge fortunately ruled, like, this was settled. We're not arguing over this anymore. And they got out of the NDA. But Kanakuk came after them for refusing to sign that clause. That's how important it was to that institution and how intimidating they were willing to be to get that family to sign away their son's voice. And it cost them $40,000 out of their pocket after already re-traumatizing and expensive legal process. So that happens in the survivor community of which I'm involved. I don't know more broadly, Kathryn, if you have other examples nationally.
No, I mean, just generally, I don't. But I'm happy to take a deeper dive if that would be helpful to this committee.
I think it would just be interesting in the context that you were just speaking of the probable inability to create a retroactive looking law versus the comment about sending a message in general about how we would view it in a cultural, political, perhaps judicial context, even though the law couldn't apply backward. It would just be interesting to know how often that comes up anyway.
You certainly have the power to pass a law prospectively.
Well, it's a great points, Representative Slauson. I'm thinking about a situation where, let's say, within the past 5 to 10 years, someone entered into an NDA that still requires future performance, maybe future payments, maybe annuity payments from an organization to a victim. And if we pass this law and that victim then speaks out in violation of an NDA, is that a material breach of the agreement, therefore excusing future performance by the other party? Can they then take the position, well, you've breached this NDA that we signed 5 to 10 years ago, and therefore we don't have to make any future payments to you? Does that make sense?
I'm just thinking, I hate to be too legal on this, but in terms of arguments to make a contract unenforceable, like frustration of purpose or impossibility, something like that, you can see it as something happening in the future, unconscionability. I mean, we have all of those in contract anyway.
Yeah. Members, if you could, I know all of you have done a lot of work on this. If you could just continue, you say you don't want to be too legal. This is the Judiciary Committee, and so we're used to it and we welcome it. We want to make sure we get this right. The Tennessee language sounds strong. We, of course, would want to make sure that it works. Something like that would work here in Texas. And the goal here is, of course, to empower victims, victors, as I like to say, to empower them and provide them the full support of the state when it comes to seeking justice and holding wrongdoers responsible. I also want to, and Elizabeth, we've talked about this, and we don't have to cover it here in the hearing, the desire for the wrongdoers or these organizations to cover this activity, and in many cases to cover for wrongdoers who are still out there on a daily basis being exposed to and having full access to children, whether it's camps or churches or Boy Scouts or sports. I mean, they're still there. Texas is in many ways, looking at what other states have done in this area, Texas is behind we are behind where we need to be and where we should be. And I fear that if we don't act in a real meaningful and strong way, we're going to almost become a sanctuary for these criminals who are preying on our children.
Yeah, and I do think that if the focus can be, in sort of a dual focus of, one, protecting survivors and letting them have their voice and not be re-traumatized, right? But the other really important piece is the connection of NDAs and the harm to future children, right? Look, I believe nothing good ever comes from a secret, right? And if we allow NDAs and child sexual abuse, we absolutely put children in danger in the future.
And to your point about the hidden predators who are going on to harm children, I'm just thinking from Cindy's story, she refused the NDA, but how many people that were victimized by Morris signed it?
I'm going to add one more thing about the protection of the future children, and that is what Sergeant Mike said. He asked the question to a room of survivors, how do we stop child sexual abuse? Our answers were no sleepovers, just common sense things to maybe protect our children. The number one way and the only way to stop abuse is to tell. And if we have to sign an NDA and we can't speak out about it, no one else is going to know, and they will be continued to allow access to children. I have a personal story with my own son as well. When one of my sons was 14, I believe at the time, and there was a father of another student at school that I caught grooming my son. And I was able to inform the school. I called that father directly and told him to not speak to my son, to stop texting him. He did not argue with me. He said, okay, which was an immediate red flag that was exactly what was happening. I was able to inform another parent whose son was very dear friends with this man's son. And 3 months later, the police were called because he had sexually abused that boy, and he finally told. And that man went to prison because we told. So whether you're telling when you see it, the activity happening, whether it's grooming, any flag, or you are able to tell after you gain the confidence, that's the only way this is going to stop and protect our future children.
I agree. Members, any other questions? Thank you to each of you. We're going to have you back. I can't remember which one of you mentioned at the top of your testimony that if the legislature decides to do something on this next session, be assured the legislature is we're going to make movement on this, meaningful movement on this and other issues next session, and we hope that you'll come back and help us actually pass meaningful legislation.
Thank
So,
you.
thank you.
Thank you.
Mr. Chairman, can I,
Yes.
before I want to thank you all for being here, I want to add one, not particularly straight on topic with what the women here have spoken about, but it has been a topic in this building over the last several sessions about sexual harassment in this building. There certainly are offices that engage in having staff sign NDAs. I think it's something that we should look at. I know that we've looked at the federal level and other states on sexual harassment and workplace NDAs as well. Not particularly on the topic we're talking about here, but adjacent to it. And I think if we're going to talk about these standards outside this building, we should be talking about the standards inside this building. So thank you all for being here.
Well, on that, so does the federal law that was passed not apply to, because it is specific to sexual harassment claims, correct?
Sexual harassment in the workplace.
Post-dispute,
Say it again?
post-dispute NDAs for sexual harassment in the workplace. So I'll send you the exact language and what several other states have gone to emphasize and go a step further at the state level based off of what the Speak Out Act was drafted to accomplish.
Okay. All right. Great point. Thanks to each of you.
Thank you.